Hello, and welcome to our Significant Developments in Government Contracting podcast. I'm Kara Sacilotto, a partner in Wiley's Government Contracts practice, and I am joined today by my partners Tracye Howard and Craig Smith. We'll be covering significant developments in the industry from 2021 to 2022 to date. Tracye will be addressing legislative developments, Craig will cover executive orders and regulatory activity, and I will wrap up with a discussion of interesting case law developments. Turning to the legislative front, Tracye, usually we see a lot of acquisition reform efforts as part of the annual National Defense Authorization Act. I understand the past year has been a little bit different. Can you bring us up to date on what has been happening on the Hill?
Sure, Kara, and that's exactly right. We haven't seen any large-scale acquisition reform this year, but as always, the National Defense Authorization Act does include an acquisition-related section. And Congress has continued to focus on some priorities that we've seen in previous years, like supply chain readiness, domestic preferences, and streamlining the process for identifying, procuring, and fielding innovative technologies. Most of these provisions require some implementing regulations. They're not self-implementing when the bill becomes law. There's also been a focus on cybersecurity. This year in the NDAA, these were more DoD internal focused provisions, and in contrast with last year's bill that had more provisions that were directly related to contractors. So turning to the supply chain issues, there were a couple of very specific provisions like prohibiting DoD from procuring personal protective equipment from North Korea, China, Russia, and Iran, as well as products made by forced labor in the Uyghur region of China or products from any entities that use forced labor from that region. DoD has already issued a class deviation to implement the PPE prohibition. And so this is an area where contractors who are in that space might need to tighten up their supply chain due diligence and adjust the companies that they're working with on their supply chain. The NDAA also extended the deadline for prohibiting procurement of printed circuit boards from North Korea, China, Russia, and Iran. And so this is going to go into effect in 2027 now instead of 2023. On the domestic preference front, this continues to be an area of focus for both Congress and the executive branch. And the NDAA this year is going to require DoD to report to Congress on violations of domestic preference laws, including the identity of the contractor and what actions DoD took in response to the violation. Domestic preference laws wasn't defined in the NDAA, but we would expect it to cover the Buy American Act, the Trade Agreements Act, specialty metals, and the Berry Amendment. There could possibly be others included as well. Again, this is an area where contractors should increase their supply chain due diligence and make sure they're in compliance with these domestic preference statutes, because Congress definitely will be looking to see that there are consequences for violations. On the innovation front, this has again been a focus of Congress for several years. They want to see DoD doing business with more non-traditional contractors and finding ways to develop and procure and implement cutting-edge technologies faster. This year, they authorized and funded some pilot programs, and they continue to encourage DoD to use other transactions. These are non-procurement contracts that don't necessarily follow the FAR. DoD is required now to collect and publicize data on those other transactions and to put that onto the Federal Procurement Data System website, the fpds.gov. So soon you'll be able to go in and do searches in FPDS for other transactions, just like you can for contracts or grants. And the last NDA provision that I want to talk about relates to threats from China. And when the implementing regulations come into effect, contractors will be required to disclose in their proposals whether any employee will perform work in China on a DoD contract or subcontract that's over $5 million. And that includes contracts for commercial products or services. So this is yet another area where prime contractors are going to need to closely coordinate with their subcontractors so that they can obtain the necessary information and put that in their proposals. DoD is going to be providing semi-annual summary briefings to Congress on this issue. So I would imagine most contractors are going to want to do whatever they can to adjust their supply chains and avoid having to make these sorts of disclosures if they can avoid it at all.
Hey, Tracye, one question I had. Normally this time of year, you're able to look into your crystal ball and start talking about the next NDAA. What are you seeing there?
So what I see is there definitely will be a next NDAA for fiscal year 2023, but right now we don't have any idea what the schedule for that is going to be, or what the content of that bill might be. The presidential budget is going to come out in the next couple of weeks, and that sort of kicks off the process. And then I would expect the House and Senate Armed Services Committee to come up with their drafts and vote on their respective bills over the summer. And as we've seen in the last few years, probably final passage wouldn't come until near the end of the year. I did have a couple of non-NDAA bills that I wanted to just touch on that significantly impact contractors as well as other companies. And that's the Consolidated Appropriations Act for 2022. This was just enacted March 15th. And at a high level, it provides appropriations for the remainder of fiscal year 2022, which we're almost halfway through, which avoids the threat of government shutdowns for the rest of the fiscal year. It also allows agencies to start new programs, which they weren't able to do when they were under the continuing resolutions for the first half of the year. But very importantly, the bill incorporated the Cyber Incident Reporting for Critical Infrastructure Act. This was part of a larger cybersecurity bill that was passed earlier in March. And so going forward, we will have a cyber incident reporting requirement for entities in the critical infrastructure sector. This has been a hot topic in Congress over the last couple of years about whether we should require entities who are victims of a cyber breach or hack or what have you to make reports to the government. And this has finally come to fruition. It is limited to the critical infrastructure sector. Reports will have to be made within 72 hours of the company understanding that an incident has happened. They'll have to report ransomware payments within 24 hours and also provide continuing updates of information. The bill also provides subpoena authority for the Department of Homeland Security. So if they feel like companies aren't cooperating enough, they now have a means to compel the information out of the companies. There are some safe harbors for reporting entities. So there's a limited liability protection based on the submission of the reports, not the incident itself, but to the extent that someone makes a good faith report about a breach or an incident, they will have some liability protections for that. The information that's provided in the reports will be considered proprietary to the company, so it can't be disclosed under FOIA, and it can't be used for regulatory enforcement. There's also voluntary reporting that's authorized, and it includes those same safe harbor provisions. There is a pretty long lead time for these regulations to implement the incident reporting. Congress gave DHS 2 years to come up with a proposed rule and 18 months for the final. So there should be a pretty good opportunity for public comment as the implementing regulations come into being.
Thanks, Tracye. Interesting stuff going on the Hill and to look forward to. Changing gears now to the regulatory environment. I know we've had just a ton of executive orders that have been issued, and I'm interested to hear your take on them, Craig, along with some of the new issues that are arising in the regulatory environment and maybe some old issues that are reappearing. Can you tell us about that?
Absolutely. And I think you hit on something, because when we did this summary last year, Kara, you talked about, hey, we're in the regulatory freeze. Well, we've thawed a little bit here and started to see some activity as we got into more of 2021 and early 2022. I thought it was interesting that Tracye started and ended talking about cybersecurity, because that's right where we started our conversation about the administration and regulatory developments. It illustrated, I think, a theme from this year, which was trying to tackle big, thorny problems government-wide. It's hard to imagine anyone who disagrees on the importance of cybersecurity, both within government and in the contractor base. But there's this real tension between moving quickly to defend against an urgent threat on the one hand, and developing regulations that work, and practically, and that do so at reasonable cost and risk to the government and the contractor base. COVID actually, I think, gave us a great example of this. Everyone had their complaints about the PPP rollout, but who wanted to wait 6 more months for every little I to get dotted and T to get crossed? Cybersecurity This year felt a little bit more like that on the regulatory side, where this tension just played out visibly. We saw it with DoD cybersecurity maturity model certification, where DoD almost rebooted, I guess, in the parlance of computer people, their original approach, and are trying to retool what they're doing. More focus on leveraging existing standards, fewer levels of certification, these types of changes to simplify the program and reduce kind of overlapping or potentially even conflicting standards across agencies. We also saw the tension play out with Executive Order 14028, where the administration set some very broad and ambitious government-wide cybersecurity goals, but the promise of we're going to have proposed rules within a few months. We're now closing in on a year since the EO, and I don't have a way to tell you when we're going to see a set of proposed rules. And this is not to be critical of government. It's more to reflect the reality of these are difficult problems that affect everyone throughout the supply chain. And there is a sincere, if not always effective, attempt to try to get the requirements internal and external to contractors right. So I think you see those same type of big thorny problems, that kind of theme, I guess I'd call it, or tonality with climate change, which was the other area that we talked about. And this administration has more of a risk tone to it. It wouldn't look out of place, some of these questions internal to maybe an insurance company trying to price out risk in the future. But here you can see there are some tentative steps into the area this year through executive orders and early rulemaking, asking about what are repeatable methodologies and valid methodologies for measuring greenhouse gas emissions over a product or service life cycle. That's actually a real question that got asked. This is not what you can see sometimes in these areas. Here's a definition we cooked up in the FAR Council lab. Please comment in 60 days, and if you don't have anything that's going to persuade us, this becomes the rule. It's much earlier in the process. Some might say it needs to move faster. Some might say it needs to move slower. But I think what we did see is it moved at a pace that reflects the tension between those two kind of competing viewpoints.
Craig, are there any areas where we don't see that tension between trying to move quickly and trying to make sure everyone has a seat at the table?
Yes, I think in labor and employment. Right before we had the boot camp, we saw DOL roll out a proposed rule that would overhaul the Davis-Bacon Act, so for construction contractors, the implementation for the first time almost in my lifetime. And while I think what's important to realize is on the one hand, we have the infrastructure bill and just there's going to be a lot of money coming out of the federal construction accounts. On the other hand, it wasn't as though there was an actual pressing need to do it other than it needs to get done at some point. What I think you saw in that proposed rule is an effort to persuade readers that the agency had really thought through a lot of the issues and tried to account for what is not actually working in practice. And as someone who works in wage hour issues a lot, I see times where I go, whatever viewpoint you have on labor and employment relations issues, some things just aren't working practically. And I think there was an attempt to get that viewpoint across. Too early, I think, in my view, to tell how effective they were at that, but at least you can see that theme. The other area that I would say the only tension is between, is this a good idea, or here's what the government did, the non-displacement rules revival, and this almost a backdoor, and I can only hope accidental effort by the Department of Agriculture to partially revive the long gone fair pay and safe workplaces requirements, or the so-called blacklisting requirements. Both of those are solutions in search of a problem, and I just look at their return and go, why? When I look at Davis-Bacon, I can understand a need to update it. You can see the thinking, whether or not one agrees with it or not. With non-displacement and any revival of fair pay, you just go, what are we actually trying to solve here? It doesn't look like the tool that's been selected is in any way going to effectively achieve the desired goal at a reasonable cost and risk to the government and the contractor community. You probably heard me saying why through WebEx over the last few months with those. Kara, maybe with some of these cases, you said why a few times too as well. Were there any in particular that stood out to you?
Thanks, Craig. I have 5 cases to highlight. 3 claims cases, and 2 bid protest cases. I'll give you the case name and citation and 1 takeaway for each. The first claims case is Tolliver Group, Inc. versus United States, 20 F 4th 771, Federal Circuit 2021. This case is about whether the complaint and relief sought in litigation at the Court of Federal Claims matched the claim that was brought before the contracting officer. The takeaway from this case is to ensure that all viable legal theories and facts are included in the claim that is presented to the contracting officer. Argue in the alternative if necessary, but don't bring them for the first time on appeal. The second case is JKB Solutions and Services versus United States. The citation is 18 F 4th 704. It's from the Federal Circuit as well, 21. This is a very unusual case interpreting the commercial item provisions of the FAR. And in this case, the court read out of the contract certain provisions to which the parties had agreed by signing the contract itself. The takeaway from this case is to be sure to review all parts and provisions of the contract, even any incorporated FAR or DFARs or agency FAR supplements. And if there's any confusion whether a particular clause should or should not be included in the contract and its material, raise it with the contracting officer. You'd rather have that settled in advance than have a board or a court read out a provision from your contract. The third and final claims case is from the Armed Services Board of Contract Appeals. It's Lockheed Martin Aeronautics Company, ASBCA number 62505. It's from June 2021, and the Westlaw citation is 2021 Westlaw 2912101. This case addressed whether a unilateral contract definitization was a government claim that could be immediately appealed to a board or court, or a contractor claim that had to first be presented to the contracting officer in the form of a claim and then receipt of a contracting officer final decision. Reviewing a long line of precedent before the board held that this was in fact not a government claim, but had to be brought as a contractor claim, the challenge to the definitization itself. The takeaway from this case is that it's sometimes difficult to determine whether a claim belongs to the contractor or the government, and whether an appeal can be brought immediately from a government claim or must first be presented as a contractor claim to the contracting officer. For certain claims that may straddle that line, it's important to have experienced counsel so that you can ensure that your rights are protected and you don't file an appeal of a claim too early or too late. Moving on to bid protest cases, the first protest case I wanted to discuss is Systems Studies and Simulation, Inc. versus United States. This is a 2021 Federal Circuit case, and the citation is 22 F 4th 994. This case is very straightforward. It involved a question of whether there is a presumption that a protester is prejudiced by an agency error in the procurement process. The Federal Circuit dispatched of this handily by holding that there is no such presumption. So the takeaway is also pretty straightforward. Protesters must establish that an agency error is prejudicial in all bid protests. The second bid protest case is Golden IT LLC versus United States. This case is from the Court of Federal Claims. The Court of Federal Claims number is 21-1966C, and the Westlaw citation is 2022 Westlaw 334369. This is a recent case from February 2022 in which Judge Solemson of the Court of Federal Claims rejected the prevailing Government Accountability Office rule on key personnel departures. To provide a little background, GAO holds that if during the course of a procurement, an offeror knows that a proposed key personnel is no longer available, even if proposals have already been submitted, the offeror must notify the agency of that key personnel candidate's unavailability. Judge Solemson, however, rejected this approach and held, frankly, that he was unable to locate any basis in the law for it. Now, the takeaway is not that this is a sea change difference between GAO and the Court of Federal Claims. Judge Solemson is one judge, and other judges have followed the GAO approach. But it is a new take on the issue that might find some traction, at least at the court. That's it for me on the case law developments. Thank you for joining us for our Significant Developments podcast. Wiley hosts podcasts in a number of different practice areas, addressing a variety of breaking legal and policy issues. We hope you'll check out all of our podcasts. Have a great rest of the day.